This question, okay, is it illegal for a facility to not allow a child to attend once learning about a diagnosis, but before learning about it not having any issues? I apologize if this is, of course it's allowed. You did it right as far as answering the question. Now, the thing is, it's very vague, so I'm going to answer it based upon just the nuts and bolts of how you wrote it. And is it illegal for a facility, and I don't know what facility you're talking about, but I'm going to base it upon this idea of that said facility receives in some form or fashion federal assistance, meaning any kind of federal dollar. At that point, they would be beholden to not only 504, but they would also potentially be beholden to the principles of IDEA, which is special education. So I'm going to sit there and expand out on your question to assume that that facility that you're referring to does in fact accept federal money in some form or fashion. Okay, so is it illegal for a family or for a facility to, see, I took my glasses off, for a facility to not allow a child to attend once learning about a diagnosis? And the answer to that is yes. It is not illegal. I mean, look, I'm an attorney, so when you say the word illegal as opposed to a violation, that it's a difference. Okay, there's nuances there, but I'm an attorney, so I've got to use the right verbiage. It wouldn't be illegal. Now, would it be a violation? Would it be discriminatory? Yes. And in that fashion, yes, it would be discriminatory if the release was because of the diagnosis. And I think it would be a lot easier to prove that if, in fact, they didn't have a problem with the child participating and attending prior to knowing that the child had a diagnosis. Okay, so there's the answer to that. Now, what do you do about it? Now, I don't know more information. So at that point, I can only sort of direct you toward a very sort of uniform vanilla type of answer because I don't have expanded information as to what type of facility we're talking about. So I will tell you that what I would direct a parent to do with this kind of information is that you need to Google Office of Civil Rights, depending on where your particular commanding office is, and there's usually one that controls I don't know, 3-4 states, maybe less, depending on the size of the state. But Google which Office of Civil Rights controls your particular state. Look on their website. They're going to have a complaint format, a template for you to follow. And then I would draft a complaint against this facility. And at that point, I would file that complaint with the Office of Civil Rights. And the Office of Civil Rights would be able to investigate this, look into it, and then they would be able to provide you corrective action. Now, because I don't know enough about your scenario and who it was and what was involved, all these other things, there may be other aspects or avenues, including a civil lawsuit, depending on what kind of damage has been done to your child as a result of being released from this program or this facility. All right. I don't have enough information to sit there and provide you like a full-scale answer. So with that, I'm telling you that there may be additional options if the scenarios that I don't know, because it's a very limited question, would denote that. So, you know, you may need to go consult an attorney. There may be additional options that you don't know exist. But with regards to immediate action, it doesn't. And by the way, if you file something with Office of Civil Rights, it does not mean that you can't go out and also consult with a private attorney. It doesn't work that way. So Office of Civil Rights can be working on your behalf while you're also discussing and even getting involved. A private attorney, if your scenario warrants a private attorney getting involved. Okay, I hope that helped.